What if the sudden green card review order being discussed right now affects more people than officials are publicly admitting? Across immigration forums, legal offices, and community groups, a new update tied to USCIS is spreading fast, raising anxiety among green card applicants and even some current permanent residents. The concern centers on reports that USCIS has ordered a new layer of review on certain green card cases, triggering delays, secondary checks, and unexpected requests for evidence. While the agency has not issued a single sweeping public announcement, multiple signals suggest something significant is unfolding behind the scenes. This update is spreading quickly because applicants are seeing similar patterns at the same time. Cases that were moving normally are suddenly paused. Interviews are being rescheduled. Approvals that seemed imminent are now marked as under review. Immigration attorneys say these changes started appearing almost simultaneously, which is why many believe the action is not random, but tied to internal guidance or a coordinated directive. According to sources familiar with the process, USCIS officers in several field offices and service centers have received instructions to apply enhanced scrutiny to specific categories of green card applications. This does not mean all cases are affected, but it does suggest a shift in how certain files are being handled. Internal guidance indicates officers are being told to re-examine eligibility factors that may have previously passed initial screening. The background to this moment goes back months. USCIS has been under pressure from multiple directions, including oversight from the Department of Homeland Security, policy signals from the White House, and ongoing litigation in federal courts related to immigration enforcement and benefit adjudication. At the same time, the agency has been working through a massive backlog while also implementing new fraud detection priorities. Officials have repeatedly said that program integrity is a top concern. In recent public statements, DHS leadership emphasized the need to ensure immigration benefits are issued only to those who fully meet legal requirements. While those statements were broad, immigration lawyers now believe they are being operationalized through targeted reviews, rather than blanket policy changes. What appears to have shifted attention recently is a combination of data matching, interagency coordination, and internal audits. Sources say USCIS is relying more heavily on information from other federal databases, including prior immigration filings, travel records, and employment verification systems. If inconsistencies appear, even minor ones, cases may be flagged for additional review. This is where confusion and fear are coming from. Many applicants believe they did everything correctly, yet they are now facing new scrutiny, months or even years after submitting their applications. Some permanent residents renewing their status or applying for naturalization worry that earlier green card approvals could be indirectly re-examined if issues are discovered during later filings. It is important to distinguish what is confirmed from what is still being reported. It is confirmed that USCIS has broad authority to review, reopen, or request additional evidence in pending green card cases. It is also confirmed that officers can pause adjudication if new information arises. However, reports suggesting a universal crackdown or mass revocation are not supported by official data at this time. What is being reported, but not formally announced, is the scope and coordination of the current review effort. Immigration attorneys across multiple states say they are seeing similar requests for evidence focused on employment history, marital timelines, prior visa compliance, and even old addresses. That pattern suggests a centralized review priority rather than isolated officer decisions. Another factor adding urgency is timing. This activity is occurring as USCIS prepares for upcoming policy transitions and budget reviews. Historically, periods like this often bring tighter enforcement and closer scrutiny, especially when agencies want to demonstrate oversight effectiveness to Congress and the public. For green card holders and applicants, the immediate concern is what this could mean next. If scrutiny increases, applicants may face longer processing times, additional documentation requests, or second interviews. In some cases, files could be referred for supervisory review. None of these steps automatically mean denial, but they do increase uncertainty and stress. Citizenship applicants are also watching closely. While this update focuses on green card reviews, any findings related to misrepresentation or eligibility could surface during naturalization adjudication. Sources say USCIS is being particularly careful with cases where permanent residence was obtained through marriage, employment sponsorship, or humanitarian pathways that require ongoing eligibility verification. Travelers are another group paying attention. Although this is not a border policy, delays or unresolved reviews can affect international travel plans. Some applicants report being advised to avoid unnecessary travel while their cases are under enhanced review, especially if advanced parole or conditional status is involved. For seniors and long-term residents, the situation feels especially unsettling. Individuals who have lived in the United States for decades often assume their status is secure. While there is no indication of widespread action against this group, attorneys warn that any new review process can create ripple effects, particularly when old records are re-examined under modern standards. Federal courts are also part of the backdrop. Several ongoing cases challenge how immigration agencies interpret eligibility, discretion, and procedural fairness. Even when courts do not directly order reviews, agencies sometimes adjust internal practices to reduce legal risk. Sources familiar with agency operations say this may be one reason USCIS is being more cautious right now. So what should viewers understand at this moment? First, this is not a confirmed policy change published in the Federal Register. Second, there is no evidence of automatic green card cancellations. Third, there is clear evidence of increased review activity in certain categories. And finally, this situation is evolving as more information emerges. Officials have not said how long this review phase may last. Past periods of enhanced scrutiny have continued for weeks or months, depending on internal findings and external pressure. Immigration advocates are urging transparency, while USCIS maintains that reviews are part of normal operations designed to protect the integrity of the system. As this story continues to unfold, the key takeaway is awareness without panic. Applicants should monitor their case status closely, respond carefully to any USCIS notices, and seek qualified legal guidance if questions arise. Assumptions and rumors can spread quickly during moments like this, but verified information remains limited and developing. For now, the message from within the system is caution, review, and verification. Whether this escalates into broader action or remains a targeted internal measure will depend on what these reviews uncover and how leadership responds. Until then, uncertainty remains, and attention across the immigration landscape is firmly fixed on what USCIS does next.